I believe we can start the meeting now. Great. The host, so let me share my screen.
So,
Yes, Nanchang, you were about to say something.
All right. Okay, so good morning, good afternoon, good evening, from wherever you are joining us from. My name is Nanchang Nangwang, and I am the Executive Director of Settlement House ADR Training Institute. And may I use this opportunity to welcome you all to this Settlement Hour, which is one of the professional development training for Settlement House ADR Training Institute. It is meant for both members and non-members alike as part of our contribution to the ADR community generally. And we are happy today, we have in our midst our very own Akshat Garg, who is going to be taking us the session. So before we commence, I just want to do a little introduction. Maybe I'll just pick few persons. You just share, tell us your name, and then tell us a little of the expectation you have for today. So we can do that quickly before we start. So I can, okay. So let's start with Bushra Ghazal. Am I correct? You can turn on your camera. Tell us who you are and what your expectations for today are. Is he with us? Okay, I can see Hawa. You can go ahead. Hello, can you hear me? Kindly confirm if you can hear me.
Yes, we can hear you, Nanchang.
Oh, okay. Okay, is there anyone who wants to go?
I believe Ayuba wants to introduce herself.
Okay, please go ahead. Go ahead, please. Okay. All right.
Please go ahead. And I also see Bowman wants to say something. Please go ahead.
Please do.
Good afternoon from my side. Sorry, I won't be able to put on my cam. My name is Joy Baliat Bowman. I'm a Nigerian lawyer. Well, I'll be expecting to learn more and to acquire more knowledge from today's training or meeting. That's my expectation.
Okay, thank you, Bowman. Okay, quickly, I can see the chairman of the governing body of Settlement House ADR Training Institute. Ma, if you are here, please, you are especially welcome. And the floor is yours. You can just greet us and declare the meeting open before we proceed.
Thank you very much, Mr. Nanchan. Good morning, good afternoon, good evening, depending on your jurisdiction. Thank you for yet another opportunity to navigate through this ADR environment that we have found ourselves. I want to especially thank our resource person for accepting to take up this meeting this morning. I also want to thank the management of Shati for organizing this robust and well-encompassing trainings, webinars for mediators, not just in Nigeria, but across the globe, as many that are interested. We're so grateful for your undoubting efforts to ensure that the community of ADR is not just known in Nigeria, in Kaduna, but it's also known everywhere, and then we are participants in the forum. I wish to welcome all of us that have logged in to this session. I believe that we're going to add more knowledge to what we have. And I believe that when we finish this webinar today, we will be better mediators and better equipped to take up any tasks that might be assigned to us. Don't be afraid to accept any assignment that is given unto you. You learn on the process. So accept it. Where you have difficulties, we have myriad of mediators, experts from different institutes. You can just give a call and ask for assistance. And I believe we're here to collaborate. Thank you very much and have a wonderful webinar.
Thank you. Thank you. Thank you so much. This is Mrs. Roskana Ankama. She's the chairman of the governing body of Settlement House ADR Training Institute. We are glad and happy to have you, Ma. And out of your busy schedules, you have always been available to help us out and support us in all that we do. We are very, very grateful. Having said so, may I, on behalf of the governing body of Settlement House ADR Training Institute, welcome you all to this edition of the Settlement Hour. Settlement House is an ADR training institute. It trains and certifies both in mediation, arbitration, negotiation, and all the ADR mechanisms. And we are hopeful that we are going to make our own contributions to the ADR world, both in Nigeria, in Africa, and the world at large. This afternoon, we are happy to have Mr. Akshat Garg to take us through commercial mediation advocacy under the Settlement Hour. I urge you all to pay keen attention, take down notes, and then drop in questions, so that all this will be addressed. Now, briefly about Mr. Akshat Garg. He's actually a new friend of ours, and he's very passionate about ADR. He is a dynamic intersection of entrepreneurship and law, and he emerges as a visionary force, both in the entrepreneurship and the ADR world. He is an enthusiast and is very eager to learn from different aspects of the ADR. And beyond his legal acumen, Akshat is a keen observer of international trade intricacies recognizing their profound impact on the global stage. His passion not only drives him to bridge gaps, but also he facilitates smooth cross-border business interactions, contributing significantly to the international business landscape. He is in India, but he has his tentacles spread all over the world in attending various ADR trainings, competitions, and the rest of them. He has entrepreneurial medical background, and he joined these things with the ADR aspects, and he creates a blend out of them. He is a testament to his innovative spirit, and he is not only he does not only address critical healthcare needs, but also showcases a relentless dedication to creative problem solving. And in addition, his collaborations with brainy baristas underscores his ability to contribute to complex contract management cases and offer ADR solutions, seamlessly blending legal expertise with practical solutions. Akshat is a fervent mentor and coach, guiding law students in ADR competitions, leading by example. He is actively participating in renowned ADR competitions like that of William C. Viskeys in the Hong Kong, and the IBA VIAC CDRC in Vienna, and APCM Australia, among many others. This is in his multifaceted role, Akshat exemplifies the integration of law, entrepreneurship, and dispute resolution expertise, offering a wealth of knowledge and experience to those who seek innovative resolutions in the modern business landscape. He's actually an interesting person to listen to, and without much waste of time, I would want to hand over the mic to Mr. Akshat Garg to guide us through the activities of the day. Thank you very much. You're welcome.
Thank you so much, Nanchang, and thank you so much, Ms. Rosenza, for your kind invitation and your kind words about ADR and India, and of course about me. I'm very glad to be here, and I'm very glad that all of you had joined this session. This shows your interest and your willingness to move the ADR across horizons and to learn more about mediation and mediation advocacy in the context. And with that, I have a small request to all of you in the very beginning, and that if you can open your videos so that we can have one-on-one interaction and in the group, so that we can know, how much we are grasping. And of course, if someone is comfortable with that. With that, I want to start with our today's topic, which is commercial mediation advocacy, navigating business conflict resolution. Now, this term navigation business conflict resolution actually misses a comma in between, which is navigating business, conflict resolution. It's, if you interpret it in the very beginning, you can understand how important it is to navigate business out of the conflict resolution, out of the conflict. And that is what, my friends, we will learn about how mediation advocacy will help you derive or navigate business out of a conflict. With that, business conflict resolution. If we break down these three words, we can put we can understand them individually, by together by two words, or together as a whole sentence. Let me tell you how. Business, as you know, is a commercial activity, buying and selling of trade for the motive of profits. Conflict is something, which is a disagreement between two or more parties. Now, if we take business and conflict together, it becomes business conflict, which is a conflict within a commercial activity. And if we take the resolution, it becomes business conflict resolution. Now that we know business conflict, we need to have a resolution. Now, if we join these three words, it becomes an activity, which is finding resolution between a business conflict. Now, you might be interested in knowing, as I told, business means buying and selling of goods and services, having profit as the primary goal of the activity. All right. And what a commercial conflict means, I know many of you have some questions that you have put in the registration form, having the question what actually a commercial conflict is. It's not, any extraordinary term, but it is very simple, as you can understand from its very words, commercial conflict, which is a disagreement or a dispute that arises within the context of a business commercial or a trade relationship between two or more parties. Now, with that, in the very beginning, I have a small task for all of you. I want you all to participate in this one. So I will play a small video, maybe around 1.5 minutes, and it will showcase different intricacies of a business process, or what are the different stages or platforms of doing business or a commercial activity. What I want from all of you, all of 19, excluding me in this meeting, to answer and identify some key areas wherein a business conflict might arise. So your task is, after I play this video, I want some answers as to where can a business conflict arise. So if all of you are ready, give me a thumbs up or a reaction in the reaction setting. Great. I see 2 thumbs up. 3, 5. It seems all of you are, sleeping. But no worries. I won't hold you any longer from your lunch. I know it is afternoon time over there. After you see this video, all of you will be waken up. Okay, here you go.
Mr. Akshat, is there sound?
There is no sound in the video. Can we get the sound?
Aside from sound, the video is cracking here. It's not playing well here.
There is no sound actually. So you will have to identify through the visuals. Is it okay?
All right, go ahead.
All right.
Sorry, at my own side here, the video is just blunt and it's slow.
I guess it's a network.
Not that it's blunt. That is how they program the video for you to enable us to identify something.
All right. So now I want answers from all of you. So in this video, where could you identify some areas where a business conflict can arise? One hint that I can give you is when you see the code and once a machine is made, that's a hint for all of you to brainstorm. And there are numerous areas. So I want answers if you can open your mics or you can simply type in the chat box. Okay, we have some answers. Workplace, organization, board, global relations, business meetings. Wow, you all are very, you know, very, very smart. You know, I don't have, oops. You all can figure out very easily. We have workplace, negotiation table, interview session. Okay. I assume some of you are still writing in the chat box. And one more thing, if anyone find it difficult to understand what I say, maybe due to the cultural difference, please let me know, or due to the technicalities, I will make sure I am understandable to all of you. Great. We have business contract, amazing answer. Signing of the contract, similar to it. Employment negotiations, correct. Employment negotiations and the labor law, industrial code, cooperations, meetings, negotiations. However, I believe HUA, negotiation is a way to resolve the conflict. We are talking about where in the business process a conflict can arise so that you lawyers can help them resolve. Office, organizations, and in our daily activities. That's a brilliant one. I didn't actually, I didn't really thought that I would get so many answers. So I have listed some of them here in the next slide. Here we go. Contract disputes. I can see many of you have written down contract, business contracts, employment contracts. Then we have partnership disagreements. As you can see in the first slide or the first shot of the video, we see 2 or 3 people. Although I can also, assume it my fault that it's not clear. It's actually a partnership. So 2 people or more than 2 people coming up, forming a partnership to do a business activity. There also can be arise dispute. Then we have, I can see many of you have written down the court. So it's actually court, but court also is a way of adjudication, or we can see resolving the conflict. But what will be the dispute? Some disputes can be of intellectual property, employment disputes, and I see Ms. Ankama has already mentioned employment negotiations. So we can cover that up in employment disputes. So let me take it one by one. One such area, I know this list is non-exhaustible. There are so many areas in a business activity where a dispute can arise very easily. But some few areas or common dispute which have occurred into this relationship and which has statistics. Number one holds is the contractual disputes. So according to the American Bar Organization, 30% of business litigation is involving of contract disputes. Now it is something which is very common, or you can easily understand it, because in every business there exists a contract. Even if you go to buy a pen from a business, from a commercial store, or you go to incorporate a company, contract is present everywhere. And one such part of contract is partnership contract. So another aspect is partnership disagreements. Maybe it can take place that you and your partner have certain disagreements, maybe due to management activity, some profit sharing ratio, some control over the business activities that may not certainly or particularly be included in a commercial contract, but still a conflict can arise between the partners. Another such aspect is of intellectual property. We have seen different types of commercial dispute arising out of the claims over certain IP rights. Some companies claim their ownership on another IP right, or some claim the infringement of their intellectual property. So we have the WIPO, which is World Intellectual Property Organization, resolving particularly for these kind of disputes. So imagine what will be the number of disputes arising in this area when we have a proper global center established only for resolving these kind of disputes. Another set of example, as you guys guessed it correctly, the employment disputes. Now, a few examples of employment disputes include the wrongful termination of an employee. And of course, you can always negotiate with your boss regarding the wages and the salary, but that certainly may not be in dispute. And the second one can be some, relating to the employment, working hours, the type of the nature of employment. Another aspect is the product activity, the product liability. Now you all consume products. You go to a store, you buy a packet of chips. Sometimes the chips is very bad, so you go to the company and you file a claim against them. So that it can be a matter of product liability. And in these types of dispute, I'll tell you in the later stage, we can resolve disputes very easily. Another aspect, the last one, may not be the last one, and since it's non-exhaustive, the commercial lease disputes. So it's involving basically of the construction or the renting or leasing of a property. So now that you know what are the types of disputes that can arise out of a business activity, now let's have a look at the resolution. Now that we know the problem, let's find out for the solution. Now, when finding a resolution, you have, I out of my research and experience I personally question when I find a resolution to a problem when a client comes with these three questions. First, will the party or the parties satisfied with the decision? So, for example, you have a client, and I believe most of you in this meeting are lawyers, smart ones. So when you have a client, you ask yourself a question, not the client, first, that whether I go to litigation or to the court, whether both the parties, since it is a dispute resolution system, it will be involving a second party. So you have to think of the other one too, not just your own client. So you ask yourself whether the parties will be satisfied with the decision. Now, generally, we have seen in when we go to an adjudicatory body, for example, an arbitral tribunal or a court, we see where are the awards or the judgment made in the favor of one, which means one party win. But what about the other one? So it may not be the case that both the parties are satisfied. Even in some cases, it's like not even one party is satisfied because of the second question, which is how much does it cost to the parties? Because as you see, when you go to court or litigation, it costs parties so much that even 10 years of time would take. And by the means of cost, we not only mean the financial resources, we mean the time and the energy. So cost means both financial resources and your time resources. And I am very sure that you as lawyers would calculate time as damages. I won't have to speak much on that. So this is the second question. The third one being, will the parties be able to continue their relationship after that? That will be the game changer if you ask that question to yourself as a lawyer. Because if you go to an adjudicatory mode, you somehow put fight or claim against the other one. This startles a relationship. This destroys a relationship. And it's a saying in India, a very popular saying, that once a thread of a relationship is broken, then if you join it back, there becomes a lump in those two threads if you join them. And it's never the same single thread. Similarly, when you file or when you take any extreme action against one party towards the other, then the relationship is somehow broken. And after, suppose you have a judgment in your favor, and then as a client, if your client wishes to do business back with that client, then there will be not the same sweetness which was initially in that relationship. So note these three questions down to ask yourself. Now, you'll ask me, Akshat, you have told us the questions that you have to ask, but what will be the answer to these questions? The answer will be commercial mediation process. Now, I know all of you are certified, most of you will be certified mediators. I won't have to much explain about that. And you can also correct in between if I go some way out of the league. So to solve that question that you ask yourself, the answer will be always leading to one point, which will be mediation. Of course, it is a voluntarily and confidential process, which is used to resolve dispute that arise in a business using a third neutral party who assist in reaching a mutually acceptable solution. Now, I have highlighted voluntarily, confidential, and a neutral party. So you cannot, when you go to a mediation, you cannot enforce or you cannot, ask a party to come to a mediation without his will. It should be a voluntary process. Additionally, a confidential and a neutral party, which will be the mediator, will facilitate the conversation in a mediation session. So it will be a cost effective, it will preserve relationship, and it will be efficient, and you will have the control over the outcomes. As you negotiate in the mediation table, as a mediation advocate, if I speak, you have the row in your hand. You can move the way of the communication or the dialogues in whichever way you want. And it will be a flexible solution and reduction in public exposure. Now, at this point of time, I wanted to give a brief about what commercial mediation is and what is the need of it, and why do you want to have to opt for it when you can do so much of litigation. So now at this point, I need some of you to tell me what do you understand by commercial mediation, and having now an idea of commercial mediation, what do you think will be the commercial mediation advocacy? The floor is all yours. You can unmute yourself, you can raise your hand, you can type in the chat box, whichever way is comfortable. So we are looking for what do you think we mediate commercial mediation? When you have now an idea of what commercial mediation is and what does it saves you? And the answer is always written on your screen. I believe you all are very hungry for your lunch at this point. So let me, yeah, go ahead. Tunde wanted to say something? The floor is all yours. Any of you? What do you think will be a commercial mediation advocate or mediation advocacy? Will it be like saying the pros of mediation? Will it be like saying no to litigation or court? What do you think it will be? Okay, so I believe all of you are still thinking and processing what it actually means. So we have few people in the chat box. Vinita says commercial mediation is the best way to resolve dispute of companies in a short span of time, saving their time, money, and energy, and also helps maintain relationship. Amazing, amazing, Vinita. Ayuba says it is a mediation proceeding in which parties settle business disputes voluntarily. Right. Both of you are very well right in explaining what mediation is. Now, let's move to the hot topic, what mediation advocacy is. Now that we have understood what true fruits a mediation can bring, now let's understand what mediation advocacy is. So mediation advocacy, is the practice which is called what a mediation advocate does. A mediation advocate is a legal profession who represents and guide parties involved in the mediation proceedings. And their primary role is to advocate for their client's interest and facilitate mediation process and help their client achieve a favorable solution. Now, we will discuss what a mediation advocate does and what should you do as a mediation advocate, as a negotiator in the next slides. But a mediation advocate is a person who represents his clients. So you are the one who talks on behalf of the clients. But of course, the decision-making authority lies with the client. Now, mediation advocate is present in a mediation setting. So this brings me to the next slide. You can see the picture over here. I have bring out a pictorial representation of what a mediation table looks like. So in the middle, we have the mediator. On both of the sides, we have the clients, and along with the clients, with the red pointed land, it is the mediation advocate. or you can say the counsels who represent the client in a mediation sessions. Now, as I told, the client has certain issues, certain disagreements, certain points of concern and goals and objectives to achieve. This is where the counsel will help in the mediation session to put forward those interests. Let me quickly take you to the role of a mediation advocate. First of all is facilitating communication. Now we have clients, mediators in the room, and of course the other party. Now, I am pretty sure that most of you will be aware of the fact that when you go to a normal court annexed mediation or any mediation by that fact, it will be like both the clients or the parties will be fighting and having strong disagreements towards each other. And despite the mediator in the between, who is the control of the session, having the charge over the session, sometimes the party, does not feel it gets representatives. And at this point of time is where the mediation advocate comes into picture. For example, I am helping my client to represent in a mediation session. There, my primary role would be to communicate what actually my client's perspective is, what my client want from the other side, what are the concerns and interests of my client, and facilitate the communication. Now, sometimes the clients do not know the process of the mediation. Often it is the general practice, which I see that clients are not usually aware. They have that old picture idea that there will be a man in between and actually you have to fight with each other. But it's not actually the fight. You have to talk to the other person and understand the perspectives. Second stage, or the second role thing that you need to do as an advocate is preparing your client. First of all, you have to explain the process to the client. I'm sure. So as I go, I want all of you to write the process of a mediation, the mediation process in the chat box. Let's see how much all of you are aware of the process. As I speak, I can see one more answer. It is the best way to solve business dispute and help parties to get a better reach. Correct, Joy. Got that right. Introduction session, that's right. Joint session. Caucus session. I can see Vinita explaining the process of the mediation. So, settlement session. That's more or less on the right track. But there is one more thing which you missed, Vinita, which is after the introduction stage, the agenda setting. So, of course, we have Ayu Tunde. Please correct me if I am buttering your names. You can anytime unmute yourself and correct your name. Right. Agenda is covered in the joint session. Thank you, Vinita. So I was saying, and all of you, all of you are pretty much aware of the session and the proceedings. First, we have an introductory session. Before the introductory session, it is mediator who can have preliminary meetings with the clients or with the counsels for that fact to brief about the nature of the dispute, to have some documents filed, which is the power of attorney, the confidentiality agreement, the agreement to mediate, and some relevant evidence or that you can that will help you to drive your conversation in the mediation session. Once you have the preliminary meeting, it is upon the mediator, then you move to the main mediation sessions. Now in the simulations you have seen a complete mediation session in I would say 45 or 1 hour, but I would say a mediation session goes in a lot of time, like it takes a lot of different and breakdown sessions to actually come to the agreement stage. So of course all of you are right, the first stage is introduction session, when the parties introduce themselves, and the client and the counsel role will explain what actually they are looking for and what actually is the points of disagreement. Then is the agenda setting, where the mediators find the common interests of the parties and help to find a mutually agreeable agenda, a neutral agenda, so that they can both discuss and formulate the points of discussion and of the flow of discussion. And then is the joint session, where actually the game starts, which is the negotiation session and the agreement stage. So you, as the mediation advocate, let's come to the second point. You have to prepare the client, explain them the process, how it goes, and explain the potential outcomes. Now, you as an advocate have to analyze what will be the potential outcome after listening to your clients. Now, at this point of time, I know it is a tendency of the lawyers to, be aggressive or assertive, like in a court, or in arbitration proceedings, any adjudicatory settings. But as an advocate, first and foremost, it is important for you to come out of that courtroom zone. You have to be in the mediation mode. You have to analyze to find what actually your client's needs are. First, you have to understand your client's perspectives. Have a client counseling session for that fact. Understand what their positions are, what actually the underlying interest behind those positions, and what actually your clients needs. Now it becomes very easier when you go to a commercial mediation session, because you can easily estimate by the trends or by looking at some documents what actually your client needs. And that becomes very difficult if you go to a family mediation, or where the emotions and the clients are much more driven by their happenings or their emotions. So bring out of that courtroom zone, escape out of that wall, and understand your client's perspective. Because remember that fact. You are there to mediate and settle, not to dominate, and not to be uh, be strengthening over the other part. Now I got few clients or few people saying and explaining me to their strategy. They were like, we'll go and they strategize everything from starting till the end. If they say yes to this point, we'll offer them this. If they say no to this point, first we'll ask them why, and then we'll press them. So please avoid using these kind of particular and strategy, because the more you strategize and the more you predict the outcome, actually in my opinion, that's the wrong way that you do. The most important thing is you need to know the tools, and you need to know how to use that tools, instead of when you will use that tools in particular minute planning. Now to using that tools, which brings me to the third point, which is gathering information. Now once you are in that joint session, now we have come to the joint session stage. You have the preliminary meetings, you have the meeting with your client, you have understood what they want. Now the session starts, and you have the start the session in the joint session after the agenda. Now this stage comes when you gather the information, ask open-ended questions, and collect the documents and data related to subject from the other side. Ask what went wrong, and what are they actually seeking. Now at this point of time, it's not advisable that you rush to a solution at the very beginning, but it is to understand what actually the other side wants and what you want. Just identify the interest. Next is strategizing and planning. This is very important as a mediation advocate. Actually, this is where your skills come in. You have to develop negotiation strategies, analyze what the case is. Now there is different kind of analysis chart. You can call it SWOT analysis. You can call it Vartna and interest analysis. Once you complete this analysis chart, you have an idea, then is the next stage to form a strategy. So strength, weakness, interest, and option is the simplest chart that I would recommend. When you have a client, when you have the meeting with your client, just take a pen and paper, or you can create a format. I have the formats. If you want, I can share those. Identify the strengths of your clients. Strengths as in strength over the other party. What are those key points where if the other party is going above you, or running ahead you, what are those points that you can make them remind the reality check? No, actually we have this strength. If you do not do this, actually you have done wrong. These kind of things. Secondly is the weakness. You have to be sure of what your client's weakness is, so that you can escape that zone very easily if the other person identifies the weakness. Next comes the interest and the positions. So can anyone tell the difference between the position and the interest? Let's see who are the getting to guest fans in this session.
So what's the question again? The position and the what?
The position and the interest. What is the difference, or how do you identify what is the position and what is the underlying interest behind those things that your client needs?
I think the interest is what each party or what the client wants out of the mediation process. And probably the position has to do with who has a stronger case out of the two parties. Because there is someone that always has a better bargaining power or negotiation power. I wouldn't know if that's what you mean with your question.
Okay, let me repeat my question. So what will be the difference between an position and an interest? So when you are having any meeting with your client, the preliminary meeting, and the right, and the person tells you what actually, this is troubling me, they have done so much wrong, then how will you identify what will be the position and the interest? I can see some answers in the chat box. Vinita says position is the demand of the client. Ondo says position is the underlying issue and interest is the outcome. Actually, this is partially right, Ondo. So let me give you a bigger picture, right? So if Yando says, I think the position is what the parties claim that they want, while the interest is what they think that they need, which may not be the actual thing that they need. Right. So this is, which the point I was coming to. It is not usually the case that you think your client wants is actually your client wants. Now, you need to, use some specialized question asking skills when you do a preliminary meeting with your clients, and even when you are in the session with the both of the parties. Because let me take this example. For example, two parties are, or two people are fighting over an coconut. Both of them wants the coconut. And but now when you ask person A, why do you want the coconut, you get to know that actually I want the coconut for the for the coconut water. I want to fulfill and I want to lay the factory of coconut waters. That's why I want the coconut for. The other person, the party B, says, I want the coconut because I have a shredding machine and I use that coconut to make use in my dishes. So the position, and as rightly said by Vinita, the interest is actually what they need or what their first demand is, which is the coconut. And what their underlying interest is, why do they want this? Because party A wants the water and party B wants the shell of it. So now if we dig into another layer after this is, again, if you ask why do they need the coconut water and why do they need the shell of it, then you come to the answer of to run their companies and to maximize the profits. And this is where you link both of these interests. Now it becomes a three-layer of questioning, and you know unveil the underlying interest with every question, and you come to the depth of it. Now these layers of interest are the layers when you identify this is actually your client wants, and this is the reason. Now suppose if party B offers, now which is the option building, when you analyze the options, if the party B offers, what if I buy the coconuts and when I shred, I'll provide you with the coconut water and the shredding water too. This actually will satisfy party A's demand of getting coconut water. Right? So the reason why you want it is now fulfilled. So this is where both of your interests fulfill. I hope you are clear what the difference between position and interest is. Good negotiators always are the principles of negotiation is you have to negotiate on the interest rather than the positions. Next is when you are in the session, you have to identify and you have to advocate for your client's interest. I believe you have a question. Ayutunde, please go ahead.
Yes, I just want to be clear about your explanation about position and interest. So are you saying that position is what each party wants out of the process, while the interest is the why they want that thing? Is that the difference or the distinction between position and interest? Position is what I want, the interest is why I want it. Is that it?
Yes, you got that right. So what questions is the position, initial question, the demand, and the underlying interest. Why do you want it is your interest. And now if you question why with again a why, then you reach another layer of interest. All right. So that's very
Thank you.
good. Thank you so much. The next is when you are in a session, you need to advocate for your client's interest. You have to be assertive as an advocate. You have to put across your point, what actually your client needs, and tell them their interest. Tell the mediator what the interests are, and ask the same set of specialized questioning to the other side, because what actually they want and why do they want it. And while being assertive, you have to be cooperative. You have to put forward your point, but also you have to understand and analyze what the other side is saying. Secondly, and most importantly, which most of the mediation advocates lose in a mediation session, is maintaining the calm and a professional demeanor. You have to be a professional man, because and it comes more importantly when you are in a commercial mediation session. You have to behave professionally and help manage clients' emotions. Now, the reason why I have put emotions in the inverted commas is it is very practical. Now, if you are a good mediation advocate, you'll know how to use the emotions of your client and the other side into the advantage of your client. First of all is you don't need to express too much emotions as the mediation advocates. On the other hand, you have to also manage your client's emotions. Don't let him drain too much emotions. Secondly, you have to identify what other parties' emotions are and label it, very smoothly. Label, so, this is what is troubling you, and, provide them sympathy, some tactical sympathy as to how, this thing happened. And one more thing is, good negotiators or good mediation advocates are the good listeners. The more actively you listen and you label the other side, the more advantageous you are, because you know what they actually want, and at this point of time you have not actually thrown your cards yet. Okay, next one is engaging in a constructive and open and option generation. Now, once you have the interest, you need to move to the resolution stage or the option generation stage. You need to figure out with your client what options you have to offer them, or what alternatives you can offer them. On the other side, you can also analyze what they can offer you and ask them whether you will be willing to give my client this, or what will be the reality check if you don't have this or we don't offer you. These are type of questions you need to ask them when you give a reality check to their offer or your offer. Now, one such strategy that I personally believe in, or that I have named it as barter strategy. It is actually the resources or the extra thing that you can uh, 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 all right, that you can offer to the other side. When you have your client, you need to put some a little brain in identifying what are those things that is a resource to your client, or which is not so much valuable to your client but can be valuable for the other side. Okay, I think I have a question from the host. Can a lawyer actually be a mediation advocate considering the nature of his job as a lawyer? And I believe I can take these questions at the end of the session, so you can everyone can collect this question, we can answer that in the end. So in the barter strategy, list those things down which you have as a resource, which you think can be a very thing very beneficial for the other side, but it may not be actually be good, uh cannot be, you can give it easy. Now I can give you an example. I was in a negotiation of a real estate thing, and one my client did one thing. We were at the trading zone and we were at the tip of a lawyer of the just settling down, and from the interest based negotiation it was turned into a positional bargaining. And at that point of time, we had the list of okay, we have a list of what we can offer them. So what my client did is, one side was saying he will be giving 50 million, and the other side was saying was stick on 45 million. Now the one side had a machinery, you know and it was actually of no use to that man. And the other person was very, my client was very smart, and actually he did surpass me in the negotiation thing. He offered him that thing, the machinery, which was not too much resourceful to him but was having a great value to the other side, because he did active listening and he did identify what will be the nature of his business, no, what he can add value to the other side. So he offered that machinery and asked for a raise to 50 million. And that deal was done instantly. Now this is the power of the resource and the barter strategy. When you have your resources, you can offer and you can change the game in your favor. It is like with an investment of 500,000, you got an advantage of 5 million. So next is helping the client in decision making. Okay. As I told you, your client has the authority to settle the disputes. You will be there in an advisory capacity. You cannot settle the disputes on your own unless you have the power given by your client. But the client will be the sole decision maker. Next thing is that you have to do as a mediation advocate is helping in drafting the agreements. Now, this thing is very helpful because as a mediation advocate, I was researching on one thing, is what are the post disputes which occur after a mediation. And when a mediation happens, there are many disputes which occur out of that mediation agreement itself. So you, as a lawyer, you have to use that legal acumen at that point of time and help the contract draft in a way which is dispute friendly, or which avoids the future dispute. Okay. Now, I can see you have a lot of questions that make you an interesting and very good audience. So we'll keep the all of the questions at the end. Unless it's a very hot topic, you can unmute your mic and ask the question. Okay. Now, but I have a question for all of you at this point of time. You have to answer: is dispute necessary to be in a mediation or to host a mediation?
Can you explain the question?
So the question is in front of you on the screen. Is dispute necessary for a mediation?
If I may answer, I would say dispute is not necessary for a mediation. Mediation can actually be used to clarify some issues and to persuade one or the other party to get to a particular conclusion.
So you are saying that so a dispute is necessary. If I can summarize you right.
No, dispute is not necessary for a mediation
Dispute
to
is not.
occur.
Okay, so right. Hoover says yes. Dana says there may not be a dispute. Grace says I conquer. Waiting for more. I think yes, dispute is necessary. Bridget says. Joy says yes. Vinita says yes. Okay, so most of you, or half, I believe half of you says yes, and half of you says no. Some of you says dispute is necessary, and some of you say no. Or both, do you have to say something?
Okay, so Miss
Okay.
Samuel has his hands on up.
Samuel, you have raised your hand. Do you want to say something? Bowman says without dispute, there won't be need for settlement. And so most of you believe that a dispute or a conflict is necessary to host a mediation. So allow me to change all of your minds. So the answer to this, and before I go to answer, Samuel, do you have to say something? You have raised your hand. Please go ahead.
Good afternoon to you, our highly esteemed resource person. We want to thank you especially for painstakingly taking us through a very insightful session. With regard to your question, asking if dispute is necessary for mediation, I think I want to subscribe to all the answers on the chat box. It actually depends on the service provider. We know basically that mediation is an act that enables a third party neutral to assist parties resolve any dispute. But some service providers have been able to go beyond waiting for disputes to fully escalate into a full-blown disagreement, whereby when you have concerns like early warning signs, an opportunity is made to nip the issue at the bud in form of negotiation, taking advantage of the whatnot at the partner. So I think the answer to that question is based on the scenario of the service provider. There are some service providers that have opportunities when individuals have concerns at an early stage. they can escalate it to a particular platform, and those concerns are looked into at an elementary stage, attended to prevent it from snowballing into something that is far much more unpalatable. Why some service providers will want to wait for the dispute to snowball into a gigantic mess before they approve any form of intervention. So it actually depends on logistics. It actually depends on jurisdiction, depends on the scheme and scope of the dispute provider. My humble thought, please.
So you say that it depends actually, and when it escalates, it depends on the service provider and the logistics, that dispute is necessary or not to go into that mediation. I would say you are partially right, but if we ask a straightforward answer whether a dispute is necessary for a mediation, the answer you'll get is no. A dispute is not necessary to go into mediation. So I believe most of you and all of you, have this view that a dispute is necessary. But the answer is actually no. Mediation is not, a dispute is not necessary to go into mediation. Let's explain, let's see how. So, when you go to a mediator, when you are in a mediation session, first question that you have in your mind is when parties can talk and finalize the deal or the dispute or the concern matter within themselves, then why do they want a mediator? Why do they want to go to a mediation session when they can talk amongst themselves if there is a no dispute? Now, question number two that you can ask is, and which is a very common assumption, is that only lawyer use mediation. Is that right? Or can anyone not go to a mediation session? Another question that really comes up, and I can also see in the chat box, is mediation is an alternative method to resolve. Now, all of these are misunderstandings and misassumptions that actually hinder the true growth of mediation and mediation advocacy that you all tend to see. And we all are trained, we all have this assumption that mediators and parties are trained in a way that there must be a dispute. But it's actually not right. When you can talk amongst yourselves, when it is an alternative way. Now, my answer to that would be, first of all, mediation or negotiation for that fact cannot or should not be called an alternative way of resolving disputes. It should be the ADR with the appropriate, not alternative. As my colleague says, that it should be the alternative method of the alternative dispute resolution to the appropriate dispute resolution. So the A should stand for the appropriate. Now, see, when we understand whether a dispute is necessary or not, whether there should be a conflict or not, you need to understand the best conflict management is conflict prevention. Because as a mediation advocate, your job is to resolve the conflict of your client. And you will be called a mediation advocate if you go to a mediation session. But your role is, as a lawyer, as a mediation advocate, to resolve the conflict. And the best conflict management is to prevent it. Okay, conflict prevention. Then comes to picture deal mediation. Now, this is a very intriguing topic when we study about commercial mediation. It is a subset of commercial mediation. So it is a mediation which does not involve a dispute among the parties. Rather, it is a mediation which is, it is a negotiation happening in the presence of a mediator. And the mediator helps the parties to reach a solution, not only a solution, but to a deal. So let me read out it for you. In negotiation, each side tries to maintain an upper hand on the other side. Now, as a mediation advocate, and as a lawyer, you have that inner gut in you to oversee the other side, to supersede the other side, and to have an upper hand over them. And sometimes parties are reluctant to share the information about their true interest or true option with them. And suppose you and your client are in a meeting or a conference with the other side, with their counsel, with their chief legal officer, and with their CEO. And as you remember in the video that I showed to you, we have different agreement signing. What if a mediator is also present in that meeting? Then these problems where the parties are reluctant, there maintains an upper side, there is the shifting of burden won't arise. Now, suppose there is no mediator and you are in a simple negotiation, a contract negotiation with the other side. There, the parties or you will eventually reach to a win-win solution or to a win-win, but that will be based on positions, and that will be the division of the pie. Because as a negotiator, if I and as an entrepreneur, if I go to another company to sign an agreement, then the both of them would agree. If they hide some information or if they are reluctant to share, they want to maintain an upper hand. These kind of questions will arise. And if we reach an agreement based on those foundations, then it will be the division of the pie. Of course, that will be a win-win solution, but it will be based on positions, not an interest that we understood before that. Now, here, what will be the mediator's role? The mediation advocate's role. As you understand, you have to identify, you have to say, you have to explain the interest, you have to put forward your views, you have to protect all of those things. But it will be, all vague if the mediator is not there in a deal mediation. Now, let's understand what will be the mediator's role. As a mediation advocate, since we are focusing this session on that, you need to understand what will be the mediator's role in this thing, because you will have to drive that conversation and remind the mediator to to protect your client, to be heard. One aspect is that the mediator helps the party to reach a deal. That's the basic, or that's the minimum that we do. Second, that mediator has to do is reaching the highest possible value for each party. Now, when we have the interest of both the sides, let's take again the coconut example. When we understand why actually we need the coconut, or when we have one wants the coconut water and one wants the coconut for shredding. If we take that example, how can we create the value out of it? Now, creating value is another dimension of mediation, where the mediation advocate and the mediator comes into picture. You have to identify some of the resources so that you can expand the horizon of the pie, not divide the pie. Suppose you can come out of a deal of more billions and creating more what you expected for, but that will only happen when you truly advocate your client's interest and identify the side's interest. Here, mediators play a role because he do not let one side overpower the other side. In a contract negotiation, in a deal mediation, the mediator won't let the risk to be shifted to the other side. Now, there was a study by the CPR Institute in Brazil. It says that most of the parties in a session, for say in a deal mediation or a negotiation, tries to shift the burden or the risk to the other side. Nobody wants to take much risk on their end, but wants them to be shifted on the other side. Now, now in this case, mediator, as a legal and as a commercial person, would understand where the risk should be allocated, and it should be equal amongst both the sides. Now, as lawyers, I'm sure you must have seen cases due to improper or the invalid contracts, void contracts, very poorly drafted dispute resolution clauses. These type of issues arise only because there is the risk which is allocated on the one side, and it is imbalance between the two. But when you are in a mediator's presence, those concerns will be taken care of. So I hope you understand how a mediator play a role when there is no conflict between. And you can understand this role or this deal mediation by different scenarios. And you yourself have told me, when there are contract negotiation, when there are employment negotiations, when there are investor state negotiations, or when there are investor to investor or state to state negotiations, where the mediator is present, these biasness will not be happening, and you will be able to create the value and reach the highest possible value for each party. And that's what actually our firm, Brainy Barrister, also does. We not only make sure that a deal is reached, but we also make sure that a highest possible deal reaches and the parties maintain the relationship. I'll give a case. We work very closely with the Indo-African Development Organization, which is INADSO. So we were having a deal or a negotiation with the Zambian government for medical supplies and the infrastructure development. So there, as a Brainy Barrister, we went as mediation advocates, and we make sure that the deal is reached. However, there was no mediator present, but as a mediation advocate, you need to identify that the deal is reached and it contains the highest possible value for both of the parties. That will only happen if you lay the foundation of the deal on the underlying interest of both the parties' businesses. You have the proper structuring analysis of the businesses. On that, you have to lay the foundation. With that, it is my saying, and I always say that a good mediation advocate resolves, but a good mediation advocate revolutionizes. And with that, I would like to bring this session to an end, and the floor is open for questions, and all of you can open your mics and ask any question if you have. Thank you so much.
All right, thank you. Okay, thank you very much, Mr. Akshat, for the presentation. It was wonderful listening to you. Can you stop sharing screen now? Okay, so thank you very much for that inciting session, Mr. Akshat. We appreciate you on behalf of the management of Settlement House ADR Training Institute. So it is time for questions. Let us indicate a virtual hand if we have questions to ask. We looked at commercial mediation. We looked at commercial mediation advocacy, and we looked at the role of a mediation advocate. And so please, the floor is open. If you have questions, please raise your virtual hand or drop the question in the chat box and it will be addressed. Thank you.
Yes, Ayotunde.
Hi, thank you for your presentation. It was actually a very good one. My question is, how do we incorporate mediation into contract documents? normally what is being done or what is mostly recognizable is an arbitration. You put an arbitration clause there and all of that. But now that we're talking about commercial mediation, it has to do with, like you said, contracts and business and all of that. So is there a standard mediation clause that one can put in a contract agreement between two business or two parties, or is just as one deem fit? That's my question.
So as far as I can understand is, you want to understand, is there any standard mediation clause which you can incorporate in the contract when you draft it, similar to arbitration clause?
Yes, please. That's my question.
Right. So of course there are standard mediation clauses. Uh, I was recently, or in the morning only, I was reading about the validity and what will be the jurisdictional question when it raised to the fulfill or the preconditions fulfilled to an arbitration agreement. And there I was reading about whether mediation clauses are held reliable or held valid by the court before going to the arbitration. And I find out that in cases of negotiation, the court usually have an opinion that it does not have a holding. Even if it is a precondition, even if it is not fulfilled, you can go to arbitration. But in cases of mediation, if you have a well drafted clause, if you have specified under which rules, which timings, and the according to a standard clause, then the court recognizes that as a precondition. If it is not fulfilled, then you cannot go to any other mode of adjudication like arbitration or to the court. Now, for your question, whether there are any standard clauses, of course there are. You can refer to the ICC mediation clause. You can refer to the APCAM mediation clause. We closely work with the APCAM, which is Asia Pacific Commercial Arbitration and Mediation Center. It has its own APCAM mediation rules, so you can do that. But of course, do not forget, when you go to the mediation, do not forget to take a skilled mediation advocate with you, even if you want to externally hire, or it is a general counsel, because there is a very huge difference when it comes to court-based attorneys and mediation attorneys. So do care of that. I hope that answers your question.
Yes, it does. Thank you.
So can we put on our cameras so that we can have a snapshot, please, as we continue with the questions? So we have a couple of questions in the chat box. As you can see, so while we open our cameras, some of the questions in the chat box, I will just read them out. Please put on your camera so that we can have a snapshot. So, first, you see, we are looking at commercial mediation. Mediation, unlike arbitration, we have commercial arbitration for a long period of time. Now, we also have lawyers who are trained in litigation and in resolving disputes. Now, we have talked about commercial mediation. We've talked about commercial mediation advocacy. So, knowing the nature of the work of a lawyer, how do you think a lawyer can actually make a good advocate, mediation advocate? How? And then what are the qualities of a mediation advocate? And do you think that a lawyer can actually fit in, considering the nature of what he does? So please, I cannot see a lot of people's camera on.
So very well. That's a very very good question to ask. Whether a lawyer or a very what will I say, a standard courtroom lawyer can be a good mediation lawyer. The answer to that can be yes, if you have the ability to switch into dual personalities. Just kidding. So, of course, the roles and the qualities differ very widely. On one side, you need to be very assertive with regards to the facts, with regards to the law. You cannot make any mistakes. You cannot give the other side any evidence to build a foundation. But in the mediation, as an advocate, you have to be diplomatic. You have to learn where to pass information, where to withhold information, and where to be collaborative. But if you ask me a very yes or no answer, my answer would be yes. Of course, you can be a good one because you know the legal intricacies too. Because when you ascertain the strengths and weaknesses, you will know what will be the best alternative to your client. What will you do if you will be in a courtroom setting? You can use that as a strength to tell the other side and to assess the partners, not to overpower, not to have a big hand over the other, but to have a reality check. Now, with regards to your second question, what will be the qualities? You first of all, quality would be you do not need to think as a lawyer, you need to think as a businessman, particularly in the commercial mediation. You need to think which will be in the interest of my client, which will bring the profits because it's commercial, which will take away the profits, what will be detrimental to my client's business, what will be not. Second, you need to be very assertive, short, smart, and crisp. You are like a shield to your client, and you are also behind that shield. You also bring the hand to for a handshake too in a mediation session. So you need to have need to be assertive like a shield, and bring out your hand for a handshake too, so that you do not also fall. So I believe these will be some qualities, and of course you can contact for any time if you want these kind of trainings, or if you want to have mediation advocates like us. Over to you.
Okay, so what actually qualifies someone as a mediation advocate?
What actually qualifies? See,
What
first,
mediation advocate? At what point can I say yes, I am a mediation advocate?
at what point? That's again a very interesting topic to discuss, because uh, of the jurisdictional barriers. Per se, in a mediation, there is no requirement that you need to bring a mediation advocate with you, or you need to be qualified to be a mediation advocate. But it's you can be a mediation advocate from day one, even if you do not have a law degree. But you can also, but only you can be a good mediation advocate if the other one of the other side praises you. You cannot be praising yourself by your own mouth. Of course, the praising should be come, and the appreciation should come from the other side. Now we have different certifications and level of mediation advocates. We have Kaushati giving the training for mediation advocacy. You can have certifications and different types of certification, and the more certifications you have, the more experience you have, of course your credibility goes up in your client's opinion, and you become more well skilled and more up. But per se there is no such requirement, but you only become good, of course, if you revolutionize. As I say, good mediation lawyers resolve, and great mediation lawyers revolutionize. So when you start revolutionizing, you become great.
Okay, so thank you very much for those answers. So we have Oyetunde. Ayotunde. Please, please, you can go ahead and ask your question.
Okay. Thank you. My question is, we know that in litigation, there are principles of laws guiding the process. In arbitrations, there are arbitration rules guiding the process. But in mediation, are there principles, are there rules guiding mediation, or does law, maybe like principles of law, legal principles, do they apply to mediation? Or you don't apply legal principles to mediation as well? Because we know in arbitration, you still apply some legal principles to arbitration. But in mediation, one, do legal principles apply? If legal principles do not apply, what are the principles of mediation that guides the process? Thank you.
Thank you for your question. That's a brilliant one, Ayotunde. So I would say, legal principles do not hold that kind of substantive value, but you have, mediation principles and you have mediation rules guiding by if you choose for an institutional mediation. We have the rules of that institutional. Similar to we have the arbitration rules, we have mediation rules. So process is taken care of by that institutional rules. Now, if we come to that joint session, uh, you know, for that particularly, we don't have a rule because it's basically structured negotiation. But then also, if you see, legal principles drives a force. If you take the example of Audi Ultram Partem, all right, no party can be left unheard. So, as a mediator, you also have to make sure that you hear both the sides. Okay, not as an adjudicatory body, but as a facilitator. It should be a neutral process. Everyone would know that both parties should have a chance to speak. So, see, we applied legal principles in a joint session, but we cannot argue on that basis because our opinion and our goal is to reach a settlement. And settlement will only happen if there is a win-win situation. Now, if we apply legal principle like which empowers only one party, then it will not be a win-win situation. It will be a complete win by one side. Okay, so in a joint session, of course, the principles of neutrality, impartiality, and similar principles apply for a mediator. You depends on the style, whether you are a transformative mediator, whether you are a facilitative mediator, whether you are a deal mediator. So these kind. So this was about the when you are in a session. Now for the entire procedure, when you submit the document, when you appoint the mediator, it is governed by the institutional rules, which you can take opt by an agreement or by inclusion of the clause in a contract. I hope that answers your question.
It does. Thank you.
Thank you so much.
So thank you very much for that brilliant question. For some of you who have not undergone the mediation skills training and certification, I think this will be an opportunity for you to do so because it will help you to become conversant and familiar with some of the things that needs to be done. To lend my voice to what Akshat has said, we have institutionalized mediation and then we have ad hoc mediation. So although for ad hoc mediation, you may not have rules, but if it is an institution that carries out, administers the mediation, they may have their own rules that are applicable. But the general principles that are applicable to mediation are very clear and stated, just as he has stated them. You have to be neutral. You have to ensure that it is party-driven. These are some of the principles that you have to consider. So thank you very much for that. And we We have a question on the chat box, which is, so you made mention earlier that conflict is not necessary. Yes, it's not necessary for mediation. So maybe I believe that quite a number of persons believe that conflict is necessary for there to be a mediation. So maybe you can give us your own thought and reasoning why you feel that conflict is not necessary, considering one of the contribution we had by Mr. Samuel, that mediation actually is an assisted negotiation. So a third party comes in to assist the parties resolve maybe a dispute or a conflict. So if conflict is not necessary, what could be the basis for the mediation? What could be the basis? What could be the reason? What could engineer the negotiation or the mediation session to the point of having a third neutral party appointed for that session?
Right. So you told me, Nanchang, that mediator is impartial, neutral. He facilitates both the parties, and by using the facilitated negotiation, he uses some certain, negotiation skills in himself to find out what is the underlying reason of those positions or of those demands. Now, in this scenario, Salacus and the Stern in their book have mentioned that where there is no conflict and we go to a mediation, it's a deal mediation. So we are actually talking of deal mediation. Now it's quite understandable by with its words. When you have to form a deal, or when you have to form the best deal, and you go in a mediation session, this session is called a deal mediation. Now, as you say that, if there are no conflict, if there is no disagreement between the parties, then the parties can talk to each other. Suppose you and I are talking to each other, there is no disagreement, and still we can reach to an agreement which can be win-win. But what if, due to our negotiation, I failed to clearly put out what I actually need, or what best I can give you? What are my resources? What are my capabilities? What if there is a situation, or no, most of the time, according to CPR study, there is situation that every side want to shift the risk, shift the burden, shift the wrong no burden to the other side. To the risk should be allocated to the other side. Suppose the breach of the contractual terms. Now you give me the breach should be happening on your side. Now these kind of risk is shifted to the other side if I am a party. And most importantly, you see this kind of negotiation or thing when one side is very huge or a big entity and the other side is not so much big entity. Then the big entity would shift the burden, shift the risk more on the weaker side or the smaller side. Now to avoid these kind of situations and to form a best deal, we have mediators, so that mediators help the parties to unfold what is actually the behind those interests. As I told, the concept of position and interest, mediators help to unfold those interests, and then out of those interests they create a pie, an expanding pie, or what actually you can give more to the deal. So first motive is to reach a deal. Second motive is to no to reach the best deal, which is best for both of them. So that would be my answer.
Thank you very much, Mr. Akshat, for that answer. So with this, do we have further questions as we round up? Questions, comments, discussion, any other question? Do we have further questions? Okay, I assume that we have no further questions. So closing comments. Let's have your inputs on what has been done thus far before we close up the meeting. Yeah,
So,
I can see our.
are you asking
Do we
for
have
my
any
closing
questions?
comments?
Not yet. The participants.
Yes,
Okay,
I'd
so
like to give a closing comment.
okay.
Thank you so much. We appreciate the organizers of this program and facilitator. However, for some of us that have experience in mediation, is there a channel or a way we can be of assistance during mediation processes? Or is there a platform where our expertise will be needed? Thank you.
There is a phone number on the there's a phone number on the group chat. You can chat me up and then we can take it up from there. We can discuss further. And then let me call on our own colleague, our senior friend. If you are with us, will you say something before we close up the session? And call Mr. Akshat to give his closing comment, and then our very own Roskama Ankama, the chairman of the governing body, will say our closing remark and close the meeting. Hawa, are you with us?
Yes, Nanchan, I'm here.
Okay.
Good evening, everyone. Good evening, our facilitator. Thank you very much for today's insightful lecture. I think commercial mediation is a new trend in Nigeria, and with our new Mediation Act, I know we are going to do a lot of things with commercial mediation. And with the advocacy, a lot of lawyers haven't actually understood what it is to be a mediation advocate. But I think with the work Settlement House is doing, a lot of lawyers will be brought on board to understand their role, the role they can play as mediation advocates. Thank you so much to Settlement House for this opportunity. And thank you so much to the facilitator. Thank you, Nancha. Hello.
Very much. Yes, thank you. Is there any other one person who wants to say something? Okay. Thank you very much for your patience, for being with us thus far. So, Mr. Akshat, your closing comment before the chairman of the governing body close the section. You can connect with Mr. Akshat on LinkedIn. He has sent his LinkedIn connection request there, so you can connect with him. You can talk, you can network. You know, that's the essence of the training. So, Mr. Akshat, quickly, as we bring this meeting.
So in my closing statement, I just want to say that thank you, first of all, to Nancheng and Shadi for this kind invitation and hosting this session, so that we can all create a group and foster each other's knowledge and share experiences so that we can learn and grow together. And at the end, I just want to reiterate what I said in the session, that good mediation advocates resolve, and great mediation advocates like all of you revolutionize. With that, thank you so much.
Thank you. So with this, I will call on the Mrs. Ankama Roskana, the chairman of the governing body of Settlement House ADR Training Institute, to say her closing remark and then bring this session to a close.
Mr. Nacha, can you please take the closing remark? I'm not in a very comfortable position to talk properly.
Okay.
Hello?
Yes, please. Yes, I can do that.
Yes, I am having network issues. Can you just take the closing remark? I'm not in a very good place right now.
Okay. All right.
Yes,
that's a noble task by the chairman of the governing body, and I'm privileged to take that. On behalf of Settlement House ADR Training Institute and the governing body, and having been delegated that authority by the chairman of the governing body, I want to appreciate everyone who has created time out of his or her busy schedule to attend this session on commercial mediation advocacy with Mr. Akshat Garg. We are very, very grateful to you, Mr. Akshat, for creating time. I believe that this should be getting to evening around your area. We really appreciate your time, your industry that you put in to this to make this session a successful one. We are grateful. We are just trying to do our best to contribute to the ADR world, to our members and to ADR enthusiasts over there. So this meeting can be found on YouTube. If you want to refresh your memory as to what has been taught during the session, we must appreciate all of you for your time. Okay, I can see. Okay. We will drop the link to the channel so that you can watch it over and over. I believe that this is actually a wonderful session. We thank Mr. Akshat for devoting his time to create a very insightful discussion and slides for our participants to see. We look forward to a very beneficial relationship and more engaging relationship from now. And I must appreciate you especially. I cannot call names, but we hold you with high regard. I can see our very own Mr. Foster and his wife, they are here. Bowman, Joy, all the way from Cyprus. We appreciate you for joining in. We can see Oyetunde, I believe she is a lawyer. Bridget, we appreciate you. Famusun, if I get it correctly, we appreciate you. How are our friend? We are really grateful for your time for staying for this about 2 hours now, listening keenly to this. We really, really appreciate you. We believe that you hold the Institute with high value and regard for you to create time to actually attend a session like this. And we pray that what you have heard and learned, you will put it into practice and then reach out to more people next time we are organizing a meeting like this. I believe that we are going to bring in more innovative topics when we have interaction with Mr. Akshat and for our benefit. Thank you very much. Okay, I can see the slides. Okay, we are great. So they are appreciating you, sir, for the slides. They were very great and very interesting. And then for those who wants to the recording, that's the YouTube channel, we will send it across to you, in fact, right away. So with this, may I officially, on behalf of the chairman of a governing body, call this meeting to a close, and we appreciate you. And we believe that when we call for the next edition of Settlement Hour, you will be available to attend, and then you can invite your family and friends. The meeting is actually a free session, but for those of you who may want a certificate of attendance, you can reach out to us, and then we will get that across to you at the token. And for those who may have further questions or clarification, you can reach out to us. We will send a message to us. We can reach Mr. Akshat, and then I believe that you'll be more than willing to attend to some of your questions. Having said so, thank you to everyone who has created this time. Just a minute, I will drop the LinkedIn, the YouTube link for you, for those who may want to watch it just quickly now. Thank you very much for your time. We appreciate you. So here is the link now for those who may want to watch it again. Okay. All right. Now on the can you confirm you can see that? All right, so thank you very much. We will can you see, have you seen the link?
No.
Okay.
No.
Okay. Minute, you will soon see.
Oh, you can't only read. Eh?
Does the channel have a name? You can just search the channel on YouTube.
That YouTube will have been better. Kò jẹ́ gbé ọwọ́ ẹ̀ kúrò kó jẹ́ kí n ṣe nǹkan tí yìí.
You are on mute actually, Nanchang.
Okay. I said you can check Settlement House ADR Training Institute on LinkedIn, on YouTube, and you will get the session Settlement commercial mediation advocacy with Yes. Thank you very much. And have a good day.
Thank you.
Bye.
Thank you so much.
Bye.